All right, so now we're ready to go. Now we're ready to go. There we go, video. My name is April Holloway, and we forgot to hit record before, so I'm gonna kind of run through this presentation for anybody who missed it, so you can get the information that you need on TPS renewal, residency, and cancellation of removal. Of course, if you have any additional questions, feel free to reach out to anyone at Latino Economic Development Center, or you can reach out to me directly. My website is holloway-legal.com. You can also find me on Facebook or Instagram, Holloway Legal DMV. So first, we're going to talk about what exactly is TPS. TPS is an authorized stay in the United States. It is not an admission to the United States, unfortunately. So if you arrived in the United States without permission and you obtain TPS, you still are noted as an entry without inspection, EWI. It does not count as an admission. However, we'll talk about advanced parole later on, which could possibly help you to obtain a lawful admission to the United States if it was taken before August 20th, 2020. There are multiple countries that currently have TPS statutes. They're renewed by Congress. So you have to look up your individual country to see what the requirements are. They are different for different countries. Someone did ask in the presentation before why they're so different, and it's because they're based on different things that are happening in that country at the time. Some TPS designations are based on natural disasters like earthquakes, and some are based on what's going on politically with the country. Like Ukraine was recently designated for TPS, and that was because of the military actions that are taking place in the country right now. There are two major limitations on TPS as opposed to a person with residency. One, it doesn't lead to permanent status. It's just a temporary authorized stay. And the other, you're not allowed to freely travel. You have to request permission to travel. If you leave the United States while you're on TPS and you did not have permission to travel, it is possible that you will either not be allowed in when you try to return to the US, or that you might be detained and placed in removal proceedings. If you want to attempt to renew your TPS status on your own, you can. The TPS status is renewed with Form 821. It's also the form you use for your initial registration. You can have TPS status alone and just be in valid authorized stay in the US. But if you want also to have authorization to work, you have to fill out a separate form, the Form I-765 for work authorization. It does not automatically come when you apply for TPS. It has to be applied for separately. And on that 765, you have the option to request a Social Security card at the time your work authorization is pending. So those are the forms that you use. If you have any complicating factors, such as a prior removal order or a certain criminal history, you may want to have an attorney to do the application or renewal for you as opposed to doing it on your own. And you do want to avoid using notarios or consultants, people who present themselves as attorneys, but they really aren't. Some of the issues that might come up when you are thinking about applying for TPS, the first includes dual nationality. This is a major issue for people who are coming from Venezuela. A lot of Venezuelans have dual nationality with Spain or Portugal. If you decide to apply for TPS, even though you have that dual nationality, you are not allowed to freely travel on that other passport. So that's something to consider when you want to apply for TPS. Also, it has to be your last country of residence. So there are a lot of people who are currently in the United States from Haiti. And before arriving to the United States, they spent a few years in Brazil, or they spent a few years in Belize. Unfortunately, that would mean that you are not eligible for TPS because your last country of residence has to be the country that has been recently designated for TPS. If you have a removal order, you may still be eligible for TPS. You just have to be honest about that removal order and be sure that there's not still some obligations you have with regards to the immigration court. You do have to have proof of entry and residence in the United States when you apply for TPS from that designated date. If you arrived on a visa, that's pretty easy. You show your visa as proof of your entry. If you did not arrive on a visa, you arrived without inspection, then you're going to look for medical records or school records, any bills that you paid, any mail that you received that has your name on the date, and date on it. And then lastly, a statement from yourself, statement from people who knew you, saying that you were in the United States at that time, can be used as proof of entry or residence. Also, you need to pay the filing fee. 1 second, I'm just checking my notes to make sure I don't forget to say anything that we said previously when we did the seminar. All right, so here's the big question. Does TPS help with obtaining residency? And there are two important things to consider when we want to know if TPS helps with obtaining residency. The first one is, how did you arrive in the United States, whether it was with permission or without permission? And the second one is, did you travel on advance parole before August 20th, 2020? So the answer to the question is, it's possible. It's possible depending on those two things. In order to adjust status in the United States, actually, let me go back and define two different things. There's the ability to stay in the US and become a resident. That's called adjusting status. And then there's the ability to leave the United States and obtain residency from your home country. That's called consular processing. So usually when people want to know if TPS can help them with obtaining residency, they want to know if they can adjust status, meaning they can stay in the United States and become a resident. And the reason for that is because in order to consular process, if you did not enter the US with permission, you have to have a parent or a spouse that is a US citizen or a resident, or else the waiver is not available to you. That sounds like a bunch of mumbo jumbo. So let's just go into some examples to kind of explain exactly what's going on so you get an idea for what's happening. So here's example one. Jay arrived to the United States from Somalia on a visitor's visa in 1990. She's maintained TPS since the first registration period in 1991. Her US citizen daughter just turned 21. Can her daughter file a petition for her? Can Jay obtain residency without leaving the United States? So let's deal with the first question. Can her daughter file a petition for you? Any US citizen child over the age of 21 and over can file a petition for their parent. That petition, however, is only the first step in other steps that are going to be required to obtain residency. The petition only establishes the relationship. It's USCIS recognizing, yes, you are parent and child. Or if it's a spouse, USCIS recognizing, yes, that is a bona fide marriage. It's a marriage that's not for the purpose of immigration. It is a true, real marriage. That's all the petition establishes, that the relationship exists. Second question, can Jay obtain residency without leaving the United States? So let's look. Jay has a lawful admission to the United States on visitor's visa, right? Her US citizen daughter is an immediate relative. So Jay can combine those two things, lawful entry with an immediate relative, and apply for residency here in the United States. Okay, so Jay's got the lawful entry and an immediate relative in the form of a US citizen daughter who is 21 years old. Let's tweak this example just a little bit. Let's say that Jay arrived to the United States from Somalia through the Mexico-US border, not on a visitor's visa. So now Jay does not have a lawful entry. Can her daughter petition for her? Yes. The petition only establishes the relationship. The petition can be filed. But can Jay obtain residency without leaving the United States? No. That unlawful entry is going to keep Jay from being able to change status. You must have a lawful entry in order to change status within the United States, in order to adjust status, excuse me, not change status. In order to adjust status, you must have that lawful entry. So if we change the scenario to say that Jay did not have a lawful entry, then having a US citizen daughter would not allow Jay to adjust status in the United States. Follow-up question, would Jay be able to consular process? So if we change this to say that Jay now has an unlawful entry, there is a waiver that is available to forgive an unlawful entry. But that waiver requires that the person have a qualifying relative that is a spouse or a parent, that is a US citizen or a lawful permanent resident. Nothing in this example indicates that Jay has those things. And so without a qualifying relative, Jay would not be able to get the waiver for the unlawful entry and would not be able to consular process successfully. Okay, let's do another example. Kay arrived to the United States from El Salvador without permission. That's usually how you'll see it written, EWI, entry without inspection, in 1991. She has maintained TPS since the first registration period in 2001. Kay used advanced parole in 2003 and re-entered the United States with permission. Her spouse just obtained citizenship. Can her spouse file a petition for her? Can Kay adjust status in the United States? So let's deal with the first question. Can her spouse file a petition for her? Yes. That's just the first step. And USCIS would look at that petition and say, is this a marriage made out of love? Or is this a marriage that's coming from the desire to receive an immigration benefit? If they agree that it's for love, they stamp their approval on it. Yes, the petition is approved. But then after that, after the petition is approved, can Kay adjust status in the United States? Well, the initial entry into the US was without permission. But look, Kay used advanced parole in 2003 and re-entered the US with permission. So Kay has a lawful entry and a US citizen spouse. Lawful entry, immediate relative, Kay can adjust status in the United States. One more. Z arrived without inspection, entry without inspection from Venezuela in 2018. He applied for and received TPS after the first registration period in 2021. He is planning to marry his US citizen boyfriend. After the marriage, will Z be able to adjust status in the United States? If no, can Z consular process? All right, so first question, after the marriage, will Z be able to adjust status in the United States? So Z does not have a lawful entry into the US. Okay, but Z does have a US citizen to a spouse to be. So is there anything that Z would be able to do to adjust status in the US? Is there anything that Z can do about that initial entry without inspection? Can Z now apply for advanced parole and use advanced parole and come back and have a lawful admission? Unfortunately, no. The advanced parole travels do not count as lawful admissions past August 20th of 2020. So there would not be an opportunity for Z to adjust status in the United States. Second question, if no, can Z consular process? Well, there's a waiver that is available for Z to be excused from the initial unlawful entry. And it requires that you have a US citizen or a resident spouse or parent. Z will have a US citizen spouse. And so Z will be able to consular process after that waiver is approved. In this case, the consular processing would take place in Colombia and not in Venezuela. But in other circumstances, that consular processing would take place in the home country. And it's usually about 3 weeks to a month that the person spends in the home country in order to get that taken care of before they're able to come back to the United States. All right, and this is going to be our last example that we do. P and J were married in Honduras and arrived in the United States in 1998. P arrived on a visitor's visa and J arrived without permission. They have both maintained TPS since 1999. P and J now have a USC son who is 21 years old. Will P and J be able to adjust status in the United States? If no, will P and J be able to consular process? So let's take P first. Will P be able to adjust status in the United States? Will P arrive on a visitor's visa? And P has an immediate relative US citizen son who is 21. So P will be able to adjust status in the United States. Lawful entry, immediate relative. Now J. J has an entry without permission, no lawful entry, and US citizen son who's 21. So no. Unfortunately, J is not going to be able to adjust status. But would J be able to consular process? The waiver for J to be forgiven of that initial unlawful entry requires a spouse or a parent that is a US citizen or a resident. In this case, in the top part of the situation, the example, J doesn't have a spouse or a parent that's a US citizen or resident. So J would not be able to consular process, but we're going to add a twist to this. J applied for and used advanced parole in September 2020. With this lawful entry, can J now adjust status in the United States? If not, is J able to consular process? Well, remember, lawful entries past August 20th, 2020 do not count as an admission for the purpose of adjustment of status. So unfortunately, travel in September 2020 was a little bit too late to meet that cutoff time. So J still would not be able to adjust in the US. And in the second scenario, J still doesn't have a spouse or a parent that's a US citizen or resident. So J is still not going to be able to consular process at this point in time. However, that doesn't mean that there are no options for J forever. All it means is that J will have to wait until P becomes a resident, and then P will be able to be the qualifying relative that J needs for the waiver in order to consular process. Okay. If you have any questions about that, please feel free to shoot me an email or contact someone at the Latino Economic Development Center, because I want to make sure that you understand this. You can also do free consultations with attorneys. I suggest doing a consultation with at least 2 attorneys whenever you're looking for someone, to make sure you have someone that's a good fit, and to also have someone who offers a plan that you want, because immigration law does have several different options for the same situation. And so you may hear different options from different attorneys. You may feel more comfortable with a different option with a different attorney. So make sure you give yourself the opportunity to work with someone who is going to be compatible to your style and what you want. Some complicating factors around TPS and residency. There are 2 additional ways that people who've been in the United States for a long time may be able to adjust status, even if they didn't have a lawful entry. And those are people who are going to be eligible for NACARA and those are who are eligible for 245I adjustments. 245I adjustments means that way back in the past, late 90s, early 2000s, that there was a labor petition or a family petition that was filed, but it was never utilized. And then now you have a new petition that is going to be filed. So those people are able to adjust even if they entered without permission. That's something that you need to speak to an attorney directly to screen for. Your ability to adjust status, even if you have a lawful entry and an immediate relative, are going to be impacted by whether or not you have a prior removal order. That includes in absentia removal orders, meaning that you never showed up to court and you were ordered removed without being there. Criminal history, if you have any issues with alien smuggling, or you might be accused of alien smuggling, or if you just have a fear of return to your home country that prevents you from being able to consular process when you would otherwise be eligible. Those are things that you need to talk through individually with an attorney to figure out what additional steps are required and what your eligibilities are. So now we're going to move into talking about cancellation of removal, or what some people refer to as the 10-year law. Before I go into that, I put this picture of the Supreme Court here because it is actually, notwithstanding current events, it is still one of my favorite buildings on the National Mall. And if you're here in Washington, DC, it is worth going to see. It's beautiful architecture, and it has been very integral to what's happening right now with cancellation of removal and with TPS adjustment of status. So it's worth going to see, and sometimes seeing something can help you remember certain things. So I think it's worth taking a trip out there. Cancellation of removal is only available for people who are in removal proceedings. So if you are not currently in court proceedings, this is not an application that you can file affirmatively. You have to be in court proceedings. The first requirement for cancellation of removal is that you have 10 years of physical presence in the United States. The way this 10 years is calculated depends on whether or not you were ever detained or ever asked to appear in immigration court. If you were never detained, never asked to appear in immigration court, then all the years that you've been in the United States will count towards your 10 years physical presence. But if you were at some point detained or asked to appear in court, your 10 years physical presence may be cut off by that notice to appear. So for example, if you arrived in the United States in 2001, you were asked to appear in court in 2003, but you never appeared in court and you were ordered removed in 2005. You may be now thinking, I would be eligible for cancellation of removal because I've been in the US for well over 10 years. But if your notice was prepared correctly in 2003, that ends your physical presence, and the court would only count you as having 2 years of physical presence in the United States. If you have been asked to appear in court, don't take that as a no. You actually would never be eligible for cancellation of removal, because if DHS made an error on your notice to appear, there may be an opportunity to claim that it doesn't cut off your physical presence. So again, that's something that you'd want to consult individually with an attorney about, to see if there's an opportunity for you to do cancellation of removal, even if you've been asked to appear in court by arguing that the notice was defective. We're going to skip number 2 for a second and go to number 3. Good moral character is a requirement. Just because you have some criminal history doesn't mean that you're going to automatically be ineligible, depending on how severe the criminal history is, how recent it was, and what things you've done to contribute to your community and your family since that time. So having a criminal history, period, does not make you ineligible, but you will want to show some remedial efforts if you did have some criminal history in the past. And now let's go back to number 2. This is actually the hardest thing in my experience for people to understand about cancellation of removal. A lot of people think that just because they have a spouse, a parent, or a child that's a US citizen, they're automatically eligible and they're going to win cancellation of removal. That's not accurate. You have to show that your US citizen or resident parent, spouse, or child would face an extreme or unusual hardship, either if you're unable to stay in the United States with them, or if they're required to return to their home country without you. I'm sorry, with you. So I'll give you a couple of examples of what we mean by hardship. One case that I handled, there were two children in the family. One child was very accelerated with math and have been accepted into a program in Germany to work with the engineers who work for BMW or Mercedes, whichever one is manufactured in Germany. And the other child had been diagnosed with spina bifida and had limited mobility and required different aids, required follow-up for a cardiac condition and other issues that presented themselves as a result of the spina bifida. The older child had had an opportunity to go back to the home country and was able to take pictures of the home the family would be living in if they were required to go back to the home country. The pictures showed the condition of the house was not at all compatible with the child's mobility aids. Also, there was no school in that area that would be available for the child to go to, whereas they were able to attend school here in the US with other children who face similar difficulties or opportunities. And so we were able to show that both children would endure hardship if they were unable to have their parents' support here in the United States, or if they were required to leave. One child would have to leave the accelerated math program that they were in and the opportunities to go and study with engineers outside of the country because the parents would not be able to earn enough money to support that anymore. And the other child would lose access to educational and medical resources that they had well established in their life at this point. So they're able to show a hardship that is different and extreme and unusual from that what other families would face if they were in the same situation. So that's what you want to keep in mind when you're talking about having a qualifying relative with a hardship for the purpose of cancellation of removal. Also, cancellation of removal is subject to caps on the number of visas that are available each year. And so a judge may tell you when you go in front of them, yeah, I plan on granting your case when the visa becomes available. And it may be a year you're going to have before that actually happens. In that meantime, that year you're going to have when you're waiting, you want to avoid having any interactions with the police. You want to stay in the United States, don't travel outside of the US. Make sure you do nothing to change your condition from the time that the judge saw you and awarded that, so you don't jeopardize your opportunity to receive that green card once the visa becomes available. The only exception to this is if you are detained at the time that you file for cancellation of removal. For people who are detained, the visa is immediately available and you'd immediately be able to get the green card once released from detention. All right, so that is cancellation of removal. Anything that we've discussed today, feel free to reach out and let me know what questions you have. You're welcome to schedule, I do free consultations if you want to know about immigration benefits that you are eligible for. Anything else, you may also contact the Latino Economic Development Center with questions about what services they also provide. Thank you so much for listening to me and being here. I appreciate all of you and I hope that you have a great day. All right, let's stop this.